The appeal in the matter of Angel and Black is limited and related appeal.
Good morning, my lords. Hopefully, in front of you, there should be a list of the representation, which I wasn't proposing to read out unless my lords wish me to do so. Along with a timetable which my Lord Justice Coulson's clerk requested last week, and the parties agreed and lodged on Thursday.
So, Stephen, you've got that now.
I've got an Opus 2 screen into which I am not logged.
We should be able to arrange that, hopefully, fairly promptly.
Is there someone from Opus 2 who could log us in? It's such a long time since I had the privilege of working with Opus 2. I've completely forgotten my password.
I'm going to have to get in contact with someone back in the office because we don't normally keep your passwords. Get it reset.
Yeah, okay.
So it might take a bit.
Well, but how do I get in?
Well, we'll have to get your password reset.
Okay, fine. Right. Okay, fine.
And this is presumably for a live transcript?
Yes, obviously my lords will get the hard copy transcript at the end of the day.
Okay. Are you content to carry on?
Yeah.
All right, well, we'll carry on.
As my lords know, the central issue on this appeal is whether a single claim form can be used by hundreds or thousands of claimants to bring unfair relationship claims against motor finance lenders. The judge at first instance, His Honour Judge Worster, sitting in Birmingham County Court, held that the 5,200 odd claimants across the 8 claim forms in these proceedings should not be permitted to bring their claims in this omnibus way. That decision was, however, overturned by Mr Justice Ritchie on appeal, who held that the approach adopted by the claimants, the respondents to this appeal, was permissible. The appellants, the defendants to the claims, respectfully say that Mr Justice Ritchie was plainly wrong to disagree with the conclusion reached by His Honour Judge Worster, a judge who was not only highly experienced in trying unfair relationship claims, but who had carefully case managed these proceedings for a period of almost a year, presiding over no less than 5 hearings. I want to start, if I may, with CPR Rule 7.3, which lies at the heart of this appeal. And if we can go, please, to my skeleton argument, which is at Core Bundle 1, tab 17, at page 280. Core Bundle 1, tab 17, page 280. We set out there the text of CPR 7.3. A claimant
I'm looking at that in the white book,
yes, my lord.
which obviously I advertised to everybody in court as being the best possible source of procedural rules. And since it's my last year of editing the white book, I encourage you all to buy it.
Well, I'm sure, my lord, there will be a great take-up on the back of.
We pass the hat round.
And we can see there, either in paragraph 4 of our skeleton or in the white book, it says a claimant may use a single claim form to start all claims which can be conveniently disposed of in the same proceedings. Now, we then set out at paragraph 5 of the skeleton a number of points in relation to the meaning and effect of CPR 7.3. And please can I ask my lords to remind themselves of what we say there before we briefly look at some of the authorities. Paragraph 5, page 280 to 281 of Core Bundle 1. Now, I do not understand any of these points in paragraph 5 to be disputed by the claimants. And as is referenced in paragraph 5.2, the leading authority on CPR 7.3 is the Court of Appeal's decision in Morris and Williams, and that is at Authorities Volume 4, tab 44, at page 1090.
Speaking for myself, Mr. Goodall, I have extracted, effectively, I have a core.
Right, my lord.
So if I'm not going to the bundles you expect me to, it's because I have a bundle of what I think are the critical documents, which include, amongst other things, Morris.
Thank you, my lord. Now, this case involved a claim by 134 investors who were advised separately by the defendant firm of solicitors in relation to their investments in one or more of 9 development projects. And the claimants commenced proceedings by way of a single claim form, seeking damages for the solicitors' alleged breaches of duty. And the solicitors applied to strike out the claim on the basis that, among other things, it did not comply with CPR 7.3. That application was refused at first instance, and the defendant's appeal to the Court of Appeal was dismissed. Now, the sole judgment was given by the Master of the Rolls, starting at page 1098. That's internal pagination, page 42. And we can pick it up at paragraph 2, where the Master of the Rolls says, against that background, this appeal concerns the circumstances in which it's permissible under the CPR for multiple claimants to bring claims in one claim form and one set of proceedings. There are, in effect, 3 regimes for such claims under Part 19, which is headed Parties and Group Litigation. The first is governed by CPR 19.1, which needs to be read alongside 7.3, which appears in the part concerning claim forms. It is that regime that is the subject of this appeal. The second regime is representative proceedings brought under 19.8, and the third regime is group litigation established by CPR 19.21 to 19.24. The argument in this court has resolved around the proper meaning of 19.1 and 7.3 and the correctness of the tests applied by the Divisional Court in Abbott and Ministry of Defence. Abbott is important because Judge Carman KC expressly followed it in deciding this case, and there is no appeal from Abbott to this court. And then at paragraph 5, we can see the Master of the Rolls says that there had been controversy over what precisely Abbott decided. For present purposes, it's sufficient to refer to paragraph 73 of Mr. Justice Andrew Baker's judgment in Abbott, where he said that if there are likely to be common issues of sufficient significance, that their determination would constitute real progress towards the final determination of each claim in a set of claims. That could be enough for conclusion that common disposal, rather than separate disposal of that set of claims, would be convenient. This can be referred to as the real progress test of whether all claims in a single claim form can be conveniently disposed of in the same proceedings. And he then set out in a nutshell the competing arguments at paragraphs 6 and 7. And then at paragraph 8, he says this: I've decided that both the solicitor's construction of 19.1 and 7.3 and the tests adumbrated in Abbott are incorrect in law. The regime allowing multiple claimants to bring their claims in one claim form under 19.1 has to be construed against the background of the previous regime established under the rules of the Supreme Court in general and Order 15 Rule 4 in particular. Even though the judge applied the Abbott test, he was right to allow the claimant's claims to proceed in one set of proceedings. Order 15 Rule 4 allowed multiple claimants where, amongst other things, some common question of law or fact arose. This formal requirement was not carried over into the CPR. It seems to me that the Civil Procedure Rule Committee could usually look again at whether it would have been better if it had been. Now, just pausing there, as we said in footnote 2 of our skeleton argument, the CPRC did subsequently consider Rule 7.3 at its meeting in July 2024, and it resolved that no amendment to the rule was required.
Yeah.
Starting then at paragraph 10, the master roles set out the essential background, and it's worth just highlighting a few paragraphs. Paragraph 11, he explained that when each of the claimants instructed the solicitors, they were provided with a standard pack of documents, including a client care letter and standard terms and conditions of the retainer. There was some variation in the wording of these documents, but the claimants maintained that the essential terms of the solicitor's retainers were the same in each of their cases. And then paragraph 13, he refers to the report on title, which was provided to each of the claimants, which were, again, immaterially the same terms. Over the page, paragraph 17, he identifies that the judge had held that there were significant common issues in these cases, including the scope of the solicitor's duties arising from the retainer letters, terms of business, and any obligations imposed by law, the questions of breach involving consideration and meaning and effect of reports on title, what losses are recoverable in principle, and so on. And then starting on page 1103, at paragraph 29, the master roles considered the Abbott litigation. And then 2 pages on, starting at paragraph 36, he surveyed the position under the rules of the Supreme Court. And then starting on the following page at paragraph 46, the master roles set out his principal conclusions and reasoning. And he deals in paragraph 47, at the foot of that page, with the issue of whether the word claimant in CPR 7.3 includes the plural, and he says that it obviously does. Then at paragraph 48, he comes to consider CPR 7.3 more generally, and he says, against that background, the next issue is as to the proper meaning of 7.3, which provides that claimants may use a single claim form to start all claims which can be conveniently disposed of in the same proceedings. I do not think that the courts need to define the meaning of a simple English word, such as conveniently. Convenience is a most ordinary word, as Mr. Justice Andrew Baker pointed out at paragraph 53 in Abbott. It was first used in our procedural rules more than 100 years ago. The question is rather, in what circumstances can multiple claims be conveniently disposed of in the same proceedings? It seems to have been common ground at the end of the hearing. The answer to that question included the circumstances described in Order 15, Rule 4. I entirely agree with that proposition for several reasons. First, it is obviously the case that claims can be conveniently disposed of in the same proceedings if common questions of law or fact arise in all the claims brought, and if the claims are in respect of or arise out of the same transaction or series of transactions. Secondly, nobody ever suggested when the CPR was introduced that a radical departure was intended from the previous position as to group actions, save for the introduction of GLOs. Thirdly, the concept of convenience appeared many years ago in Order 15, Rule 5, where it's provided that if 2 or more plaintiffs were parties and the court thought that their joinder might embarrass or delay the trial or was otherwise inconvenient, separate trials could be ordered. It is this rule that seems to have been used as a foundation for the simplified words in 7.3. And then in paragraph 49, he comes on to consider the tests promulgated in Abbott. And he says that he described the 3 tests as the real progress test, the real significant test, and the test that requires the determination of common issues in a claim by multiple claimants under 19.1 would bind all parties. And he says, I do not think any of these tests is appropriate to exclude cases from the ambit of 19.1. It seems to me that 19.1 and 7.3 must be construed as meaning what they say. Any number of claimants or defendants may be joined as parties to the proceedings, and claimants may use a single claim form to start all claims, which can be conveniently disposed of in the same proceedings. There is no exclusionary rule of real progress, real significance, or otherwise. The court will determine what is convenient according to the facts of every case. We refer to this decision of Judge Worster in the County Court of Birmingham in Angel and Black Horse. Now, just pausing there, that is, of course, the first instance decision in the present appeal, where he decided that it was not convenient on the facts of the case for multiple claimants to be joined in a single set of proceedings. All the individual claims demanded a separate evaluation of whether the separate relationship between the claimant and the defendant was unfair within the meaning of Section 140A. No joint remedy was sought, and each claim was legally distinct and turned on the particular facts of the case, and a finding in one case would not bind the situation in another. The facts are quite different here, where there are common issues, as the judge found. It seems likely, at least, that findings on the common issues the judge identified will apply to, and depending on the precise nature of the issue and any further orders made, bind all the claimants. And then in paragraph 51, he says, I accept that multiple claims will probably be capable of being conveniently disposed of in the same proceedings, where common issues will bind all or most of the claimants. But I do not think that is currently a requirement of the CPR, nor therefore is it the correct test. There is no test beyond the words of Rule 7.3, even if it is clear that cases within the old Order 15 Rule 4 and cases where common issues will bind all the claimants will obviously be capable of being conveniently disposed of in the same proceedings. And then over the page, paragraph 56, he says, I should also make clear that I'm not saying that the matters considered in Abbott were irrelevant to the question of whether it was convenient in that case to dispose of those claims in the same set of proceedings. Many matters will be relevant to that question, but the matters that are most relevant to the ultimate question of convenience will vary across the wide spectrum of cases that have been and will in the future be brought under 19.1. This court would not wish to confine the discretion of judges in deciding that question under rules that are written in plain English. And then in paragraphs 59 to 60, he identifies his conclusion and how the appeal should be disposed of, and again reiterates that Abbott did not adumbrate the correct approach. And then in 60, it cannot be doubted that on the judge's findings of fact as to common issues, the claimant's claims would have satisfied the requirements of Order 15 Rule 4. This was not seriously contested in an argument. The judge found that common questions of law or fact arose in all the claimant's claims, and the claimant's claims all arise out of the same series of transactions. In these circumstances, it seems to me there is no point in sending the case back to the judge to apply the correct test. We can make that decision now. The claims brought by the claimants in a single claim form can be conveniently disposed of in these proceedings. And then conclusions starting at paragraph 62, and it's, he says, I concluded, as I already explained, that Abbott was wrong to suggest that 7.3 required the court to apply the real progress test, the real significant test, or a requirement that the determination of common issues in a claim by multiple claimants under 19.1 would bind all parties. 19.1 and 7.3 mean what they say. Any number of claimants or defendants may be joined as parties to proceedings, and claimants may use a single claim form to start all claims, which can be conveniently disposed of in the same proceedings. The court will determine what is convenient according to the facts of every case. There is no test beyond the words of 7.3, even if it is clear that cases within the old Order 15 Rule 4 and cases where common issues will bind all the parties will obviously be capable of being conveniently disposed of in the same proceedings. So, my lords, whether it is convenient for the claims of multiple claimants to be disposed of in the same proceedings will turn on the particular facts of each case, but is likely to require at least some commonality between them, whether of law or fact. Where, in contrast, as we say is the position here, the individual claims demand a separate evaluation of whether the particular relationship between an individual claimant and the defendant is unfair, with each claim turning on its own particular facts, with a finding in one case not binding the situation in another. We say it is not convenient for the multiple claims to be disposed of in a single set of proceedings. Now, much of what the Master of the Rolls said focused on the word convenience, but it's also important, we respectfully say, not to lose sight of the words disposed of in Rule 7.3, and I do not understand it to be an issue that those words mean finally determined. And the important point to note for present purpose...
It's a process leading to disposal.
Well, my lord, we say it's the end point rather than the process.
Yes, well, if you lump them all together, they will come out at the other end disposed of.
Together.
Not necessarily. Groups may be disposed of together. Those groups may provide clear guidance for others, or the litigation can be set up so that they bind others.
Yes, but
it's not simply the end point. What I'm picking up is the point that's made, I think, in your skeleton, that case management is irrelevant, and I, for one, would not subscribe to that view willingly, because case management is all about how to manage the disposition of the cases.
Well, that was the point I was about to make, and I'll show my lord the authority on that. We say that final determination is by definition focusing upon the end point of the determination, or the end point of the proceedings, not their journey to that destination. So it focuses on the end point rather than, as it were, the journey to the destination. And this was a point made by Mr. Justice Andrew Baker, with whom Lord Justice Dingemans agreed in Abbott, which is at authorities...
We're not bound by that, are we?
No, you're not bound by that. Abbott is at authorities, volume 3, tab 40. That's at page 991.
And what's the paragraph?
Paragraph 51, my lord, which is page 1006, where he says, first, it was common ground. I also agree that disposed of here means finally determined to the extent disputed. That is not the same as case managed or the like. If many claims in the cause of action sense would be conveniently determined in a single set of proceedings, so they could be properly brought on a single claim form, it may well be convenient for them to be case managed together, even if there are multiple claim forms and no consolidation. But it can also be convenient to manage multiple sets of proceedings together, although there is no thought of common disposal, and it would offer no particular convenience as against separate disposal. And he makes the same point again in paragraph 66 on page 1009. Where he says the conclusion in paragraph 63 above and the rejection in paragraph 64 above of the view that CPR 7.3 requires a single final trial hearing to be possible or practicable do not create self-fulfilling circularity, as Mr. Platt argued. He said that nowadays there will be a case management solution to almost any complication or broadness of scope of proceedings. Therefore, he contended, unless there is a requirement that a single final trial of all claims could take place, it would be possible to say of any cohort of claims asserted by any group of claimants, as long as they have common representation, so they can be co-claimants, and the claims can be managed without separate proceedings, and CPR 7.3 is thus satisfied. But that wrongly equates convenience of common disposal with case manageability, and it overlooks the burden, which will be on the claimants if the point is taken, to show it's convenient for the determination of the multiple claims to be achieved in the same, i.e. a single set of proceedings, rather than in multiple sets of proceedings. In that regard, I agree with a different submission advanced by Mr. Platt. He argued that the fact that the parties' common case management proposals were not derailed as to their substance by Master Davison's decision indeed they've since been approved by him and Mr Justice Garnham and are now being implemented, did not establish that common disposal was convenient. That was a fair riposte to reliance by Mr Steinberg on the case management reality as the proof of the pudding being eaten. Again, but on the claimant's side this time, that reliance wrongly equated case management ability with common disposal convenience. And we would respectfully say that that is right, that the language of 7.3 is focusing upon the end point, the destination, not the journey.
So case management's irrelevant, even though case management is all about getting to a sensible end point.
Well, not irrelevant, my lord, but just because the cases can be managed together, or are capable of being managed together, or might sensibly be managed together, doesn't itself mean that 7.3 is satisfied.
It's not determinative,
No.
but it's not irrelevant.
Well, my lord, it's something that can be taken into the mix.
It's not irrelevant. Because taken at face value, paragraphs 51, 66 and 67 could be read as suggesting that this is another exclusionary rule and that the considerations of case management are irrelevant, but you accept that they're not.
I don't think he's saying it's exclusionary rule, and certainly there's nothing.
But if someone's tempted to interpret it in that way, you would say that would be wrong.
I would.
Thank you.
And certainly there's nothing in the Master of the Rolls decision to suggest this passage is wrong.
No, that's true.
And indeed, as I said at the outset, but paragraph 5 of my skeleton sets out what I understand to be points that are not disputed. And one of the points we make in that paragraph is that the case management, common case management, is itself not the determining factor when it comes
not necessarily determinative. I can live with not necessarily determinative.
I can live with not determinative.
No,
But
Well, we can fight about that
not,
later.
but not irrelevant.
not
You can take into account case management as being a potential factor, depending on the facts, when looking at convenience.
if you're satisfied that the disposal, as I say, there's two separate parts of 7.3 which need to be read together: convenience and disposed of together. And the disposed of together, I think, is clearly accepted to be final determination. And you can't, we would respectfully say, use the fact that proceedings can be case managed together as a means of saying that 7.3 is satisfied.
But that's impossible submission, because one of the things that one is doing right at the outset on any multi-party action is considering whether the convenient disposal of the whole number of claims can be achieved. And one is looking at always, as a first instance judge, to seeing whether it can be achieved, taking into account the necessary case management decisions.
Yes, I don't dispute them, my lord. My point is, just because you satisfy yourself that they can be case managed together, that does not equate to
It's not necessarily determinative
of 7.3.
or not determinative.
Now, my lord, other than the present proceedings, there have been two decisions regarding 7.3 since the Court of Appeal's judgment in Morris. The first was in a case called Adams and the Ministry of Defence, and that's at Authorities, Volume 4.
Mr. Goodall, can I just indicate the submissions spend a lot of time batting forth first instance decisions. We think it unlikely that those are going to be determinative of our decision, because they all turn on their own facts. So I just make that point in the hope that that means that people spend their time focusing on the things that we will be interested in, rather than whether Judge Kelly was right or wrong and whether that's inconsistent with Judge somebody else, because that won't decide this case, and that's a promise. Right, so Adams...
Well, my lord, having heard what my lord says about that, can I just identify the point that I take from Adams,
Yeah,
and
sure.
indeed the point that I take from Abernethy and Barclays. And that is that in both those judgments, and I'm not obviously dissenting from the fact they're first instance judgments, but in both those judgments, the point is made that if ultimately there's going to need to be an individual determination at the end of the process, that itself is a strong indication that 7.3 is not satisfied.
The benefits of the individual claim form are short-lived.
Exactly, to use the language of Mr. Justice Garland. So I'm very happy to pass over both.
Sorry, let me just get the proposition you get from that. If there will need to be an individual determination of each case, do you say?
Each individual claim. Individual claim, yes.
That is a strong indication that
7.3 is not satisfied.
What? Can we just test that a fraction? Because it's absolutely typical with multi-party claims that there are some differences, or that you may have differences which themselves need individual determination.
Yes.
And yet there may be sufficient commonality or whatever it is to tip the balance in favour of joint management and even omnibus. I like the word omnibus claim forms. So it's a balance, isn't it?
Well, my Lord, one has to think quite carefully about what actually one is talking about with individual determinations. If you have a situation like, for example, Morris, where Master Rolls and indeed the managing judge had identified various defendant side common issues, hard edge common issues. Was there a duty of care? What was its scope? You know, what's the proper meaning and effect of a retainer? What's the proper interpretation of the report and title? The judge, the trial judge, having determined those issues, they will all roll out across the whole claimant body. They won't need to be re-examined again in any separate individual determination. I mean, yes, I accept there might then be individual determinations of loss, maybe reliance.
Quantum causation.
Quite. But in that situation, one is not having to revisit the very thing that's been determined as part of the common.
I agree with that.
And that's where we say is the fundamental difference here. That there are no common hard-edged issues that can then be determined and resolved across the whole cohort. That's the difference, my Lord.
So the risk of that, or the potential risk of that, that's effectively saying, so the test is whether there are issues on which there can be binding decisions. And Morris tells us that isn't.
I'm not saying that, my Lord. I'm saying that there are issues that have been disposed of on a common basis that won't need to be revisited as part of the individual determination, because the individual determination left, if it's required at all, is on points like, in, for example, Morris, questions of reliance, questions of quantum.
Because there's already been a binding decision on the common issue.
But the fact is binding is not, as it were, critical to my argument, my Lord. It's
Well, it is, because it's binding, you're not revisiting it.
Well, it's because it's common, you're not revisiting it. Right? It's a truly common issue. It's a truly common hard-edged issue. You know, what is the meaning and effect of this retainer? What is the proper interpretation of this report on title? What is the scope of duty owed by the Ministry of Defence in Abbott? These are all issues which are common, properly common, that having been resolved, just apply across the piece. And what's left, insofar as there are individual determinations, are points that are specific to that claimant, i.e. reliance, quantum, and so on.
You're right in the middle of the traditional or conventional case management, because one of the questions that I would like you to answer at some stage is, what difference to the case management powers of the court does it make whether you've got one claim form, 8 claim forms, or 5,000 claim forms in this case, in this litigation? Because at the moment, I can't immediately think of any case management power that is available if you have 8 claim forms that is not available if you have 5,000, however many claim forms, and vice versa.
But my lord, we would say that's a point, and we respectfully say so in our favour, in the sense.
It may be. I'm not only asking you things that necessarily
in the sense
you're going to have to work it out.
It allows the judge, the managing judge, to work out what is the appropriate way to manage this cohort of cases. And we respectfully say that the answer to my lord's question does not point in the direction of saying, oh, well, because that's the case, there should be...
In that case, why is anybody spending 5 bob, let alone £1 million, on whether we have 1, 8 or 5,000 claim forms?
Because, my lord, we say that the superstructure that's been put in place as a result of Mr. Justice Ritchie's decision, you know, with a big cohort of claims going forward, with a whole sampling process, it's just A, unnecessary, and B, is only going to serve to increase.
Well, that's a different question, which is whether the case management orders that have been made are appropriate or should be struck down. But I think you're accepting, and I'm not sure that even with this panoply of representation here, you're binding your colleagues. You're accepting that the case management powers are the same whether you have 1, 8 or 5,000 claim forms.
Well, I have to accept that whether you've got 5,000 claims on a single claim form or 5,000 separate claim forms, it's open to a judge under the conventional powers in the CPR to manage those cases as he or she thinks fit. And that does allow a managing judge to manage the 5,000 cases if thought appropriate.
So does that mean that the real issue that we're talking about in this appeal is not the number of claim forms, but what you do thereafter?
Well, no, my lord, with respect, the real issue is the convenience test satisfied? And we say no. Secondly, and related to the first point, is we say whichever way you cut this, you are ending up with 5,000 individual determinations. Mm-hmm. And that itself is a strong indicator that 7.3 is not satisfied.
But it doesn't matter,
because
the case management powers of the court are the same whichever way we go.
But it does matter, my lord, because in the instance of what the judge has done here, we have this whole superstructure of sample cases going off to trial, but actually the whole thing is futile, because actually at the end of the day, you're going to need what you would have anyway with these claims going through the small claims track of individual determinations of that relation.
Let us be absolutely clear. Your position is that unless in the normal war of attrition that goes on, some people fall out, but however many people are still left, each of them will have an individual trial.
Yes.
That's absurd.
My lord, it's not absurd. That's what we respectfully say, and I'll show you in a moment.
But let me rephrase that, because it's not an appropriate word for me to have used. That would, in my provisional view, be a gross failure of case management. That's my provisional view. It doesn't mean to say that I think that Judge Worster was right or can be overturned or not or whatever. But surely what the court should be looking at, and 7.3 is just part of this process, is a way of expeditiously getting this litigation, these claims, done.
Well, in fact, my lord, and I will come on to this later on, His Honour Judge Worster identified the way he thought that should happen. He said the way this could happen very easily is to transfer a couple of these small claims onto the fast track and get them decided, and let's see what happens then. Now the judge, Mr. Justice Ritchie, paid no regard to that at all. But we respectfully say that is the right way to do it. If there are, a collection of cases that can be tried quickly on the fast track, insofar as there really are points of principle here, which we say there aren't, that will resolve the issue. And those cases can go up through the appellate courts in the very same way that each and every headline unfair relationship claim has gone up through the appellate courts on an individual basis, that Plevin, Smith. So there's no... The problem we respectfully say, my lord, is that the judge became, with respect, quite blinkered. He just saw this as
Judge
being...
Worster.
No, Justice Ritchie.
Okay.
He just simply thought, well, this all needs to stay together. It's the only way it can work. But actually, that's not true, because His Honour Judge Worster had provided an alternative. And we respectfully say that as my Lord has identified, the cases are capable of being managed, if that's what's appropriate, without being on a single claim form. And the problem is that Mr. Justice Ritchie became too focused upon keeping them all together, which we say just ignores the fact that at the end of the day, whichever way you cut it, allowing for some dropping out, some settling, whatever it might be, there will need to be individual determinations insofar as they are pursued.
Thank you.
Now, I think having had my Lord Justice Coulson's indication on Adams and Abernethy, I will move on from those. But my Lords have the...
So, we have your proposition that if there needs to be an individual determination of each claim, that's a strong indication that 7.3 is not satisfied.
Yes.
Yeah.
Well, let me just show my Lord, if I may, very quickly, some passages from Adams. I won't read them, but I'll just give you the references so you've got them, so I can show my Lords the support for that. So Adams is authorities for tab 45.
Yeah.
And if my Lords in due course could read paragraphs 17 to 19. 21 to 23, and 23 in particular makes the point I made about prima facie, if you need individual assessments, then it's not convenient for them to be disposed of together. And also 26 and 27. And then in Abernethy, I'll just give you the references.
When, because I've read this passage, when Mr. Justice Garnham at 22 talks about the cases have already been disaggregated.
I think, my Lord, that was because of what he explained in paragraphs 1 to 6 about there being a problem with the CE file. And in essence, every case having to be given a separate case number because there was a problem in that case about the way in which CE file could handle the individual claim.
So when he talks about maintaining not disturbing the status quo, that means not disturbing the fact that because there was a problem, there were individual claims.
Well, no, I think both parties, you can see in paragraph 20, were saying the claims shouldn't be disaggregated. So when he talks about them being disaggregated, he's talking simply about there being separate claim numbers available through the CE file process. He wasn't there making observation about 7.3, I don't believe.
Right.
So that's Adams, and then Abernethy is authorities for tab 50, and a similar point is made by Her Honour Judge Emma Kelly at I believe it's paragraph 100. If my Lords in due course could read 155, 156, and 158. She makes the same point that effectively individual assessment or individual determination is the antithesis of what is required under 7.3. Now, I want to then turn, if I may, to consider the nature of an unfair relationship claim, which, as the Court well knows, is a statutory claim under Section 140A of the Consumer Credit Act. And my overarching submission here is twofold. First, that an assessment of fairness under Section 140A involves an extremely broad inquiry, which will be highly fact sensitive. And second, should unfairness be established, the remedy that should be afforded under section 140B, if any, is also highly fact specific. Now, there have been three relatively recent decisions of the Supreme Court which have considered these provisions, and those are Plevin, Smith and Royal Bank of Scotland, and the recent motor finance judgment in one of the three cases heard on appeal, namely Johnson and First Rand Bank. And I propose to look briefly at each, if I may. Plevin is at Authorities 1, tab 19, at page 309. Now, this case concerned an unfair relationship claim brought by an individual who had entered into a credit agreement with a lender arranged by a broker. And as part of the agreement, the broker had arranged for the claimant to take out payment protection insurance, PPI, in respect of which the claimant paid a premium, 71% of which was made up of commission, which was not disclosed to the claimant and was shared by the lender and the broker. And Lord Sumption gave the sole judgment, and there are a handful of passages I'd like to just highlight, if I may. Starting on page 313, at the foot of that page, paragraph 7, Lord Sumption set out what he described as general considerations in relation to the statutory provisions. And you can see over the page at paragraph 8 that he sets out the terms of section 140A, which provides that subparagraph 1, the court may make an order under section 140B in connection with a credit agreement if it determines that the relationship between the creditor and the debtor arising out of the agreement, or the agreement taken with any related agreement, is unfair to the debtor because of one or more of the following: A, any of the terms of the agreement or any related agreement; B, the way in which the creditor has exercised or enforced any of his rights under the agreement or any related agreement; C, anything done or not done by or on behalf of the creditor either before or after the making of the agreement or any related agreement. And then subparagraph 2, in deciding whether to make a determination under this section, the court shall have regard to all matters it thinks relevant, including matters relating to the creditor and matters relating to the debtor. And then at paragraph 10, lower down that page, he says section 140A is deliberately framed in wide terms with very little in the way of guidance about the criteria for its application, such as is to be found in other provisions of the Act conferring discretionary powers on the courts. It is not possible to state a precise or universal test for its application, which must depend on the court's judgment of all the relevant facts. Some general points may, however, be made. First, what must be unfair is the relationship between the debtor and the creditor. In a case like the present one, where the terms themselves are not intrinsically unfair, this will often be because the relationship is so one-sided as substantially to limit the debtor's ability to choose. Secondly, although the court is concerned with hardship to the debtor, section 140A2 envisages that matters relating to the creditor or the debtor may also be relevant. There may be features of the transaction which operate harshly against the debtor, but it does not necessarily follow the relationship is unfair. These features may be required in order to protect what the court regards as a legitimate interest of the creditor. Thirdly, the alleged unfairness must arise from one of the three categories of cause listed at subparagraphs A to C. Fourthly, the great majority of relationships between commercial lenders and private borrowers are probably characterised by large differences of financial knowledge and expertise. It is an inherently unequal relationship, but it cannot have been Parliament's intention that the generality of such relationships should be liable to be reopened for that reason alone. And then starting on page 316, at paragraph 14, Lord Sumption addresses the non-disclosure of the Commission arrangements. And we can pick it up at the next page, page 317, at paragraph 17, where he says, the view which a court takes of the fairness or unfairness of a debtor-creditor relationship may legitimately be influenced by the standard of commercial conduct, reasonably to be expected of the creditor. The ICOB rules are some evidence of what that standard is, but they cannot be determinative of the question posed by section 148 because they are doing different things. The fundamental difference is that the ICOB rules impose obligations on insurers and insurance intermediaries. Section 148, by comparison, does not impose any obligation and is not concerned with the question whether the creditor or anyone else is in breach of a duty. It's concerned with the question whether the creditor's relationship with the debtor was unfair. It may be unfair for a variety of reasons, which do not have to involve a breach of duty. There are other differences which flow from this. The ICOB rules impose a minimum standard of conduct applicable in a wide range of situations, enforceable by action and sounding in damages. Section 140A introduces a broader test of fairness applied to the particular debtor-creditor relationship, which may lead to the transaction being reopened as a matter of judicial discretion. The standard of conduct required of practitioners by the ICOB rules is laid down in advance by the FSA, whereas the standard of fairness in a debtor-creditor relationship is a matter for the court, on which it must make its own assessment. Most of the ICOB rules, including those relating to the Disclosure Commission, impose hard-edged requirements, whereas the question of fairness involves a large element of forensic judgment. It follows that the question whether the debtor-creditor relationship is fair cannot be the same as the question whether the creditor has complied with the ICOB rules, and the facts which may be relevant to answer it are manifestly different. An altogether wider range of considerations may be relevant to the fairness of the relationship, most of which would not be relevant to the application of the rules. They include the characteristics of the borrower, her sophistication or vulnerability, the facts which she could reasonably be expected to know or assume, the range of choices available to her, and the degree to which the creditor was or should have been aware of these matters. And then coming on to paragraph 18, can I ask my Lords please to read that?
Paragraph 18.
Paragraph 18, where Lord Sumption refers to what is often now called the tipping point. My Lords, that's Pleadon, and I'll come back to the tipping point in a moment. And the next case is Smith and RBS. That's Authorities 3, tab 38. Page 915. This was also a PCI case, but the principal issue concerned limitation. But in the course of his judgment, Lord Leggett, who gave the lead judgment, made a number of observations in relation to unfair relationship claims. His judgment starts at page 923. and he addressed the statutory provisions starting on page 925, starting at paragraph 12, and then on the following page, at starting at page 16, he identifies how the regime works. And he says at 16, it can be seen that in dealing with a claim by a debtor under these provisions, the court is required to follow a two-stage process. The first stage is to determine whether the relationship between the creditor and the debtor arising out of the credit agreement is unfair to the debtor because of one or more of the matters specified in section 140A1. If the court finds that the relationship is unfair for that reason, the court must then proceed to the second stage and decide what, if any, order to make, selecting from the list of options in section 140B(1). Some further general points may be made which are apparent on the face of sections 140A to 140C. First, under section 140A(1), it is not the fairness or otherwise of the credit agreement which the court must determine. It is whether the relationship between the creditor and the debtor arising out of the credit agreement, on its own or taken with any related agreement, is unfair to the debtor. A relationship by its nature extends over a period of time and may continue for as long as there is any sum payable or which will or may become payable under the credit agreement. Second, the question to be determined under section 140A(1) is not whether the relationship between the creditor and the debtor was unfair to the debtor when the credit agreement was made or at some other time in the past. It is whether the relationship is unfair to the debtor, i.e. at the time when the determination is made. This is reinforced by section 140B(9), which is likewise framed in the present tense. We can then, I think, jump over paragraphs 20 and 21, which expand on that point, and pick it up on page 927, paragraph.
Because that's all concerned with the limitation issue, which was
Yes.
the point in issue in the case.
Pick it up at paragraph 22,
Yeah.
where he says a third point, which is apparent on the face of the provisions, is the breadth and open-ended nature of the assessment required by section 148. The court is not left entirely at large, as subsection 1 requires the court to decide whether the relationship is unfair to the debtor because of one or more of three specified matters. These three possible causes of unfairness are, however, extremely broad, and he then sets them out. And he says, just beneath the letter B, it would be hard to cast the possible causes of unfairness more broadly than this. What is more, subsection 2 makes it clear that there is no restriction on the matters to which the court may have regard in deciding whether the relationship is unfair to the debtor, provided only that the court thinks them relevant. Subsection 2 also makes it clear that if any matter is thought relevant, the court not only can but must have regard to it. The breadth of the matters that may be thought relevant is illustrated by a list of examples given by Mr. Justice Hamlin in the Deutsche Bank case. And then paragraph 23, fourth, the descriptions of the possible causes of unfairness in section 140A 1A to C demonstrate that for the purpose of deciding whether the relationship is now, or was when it ended, unfair to the debtor, the court must consider the whole history of the relationship, going back not only to the making of the credit agreement, but to any relevant act or omission of the creditor before the making of that agreement, or any related agreement. This is so without any limit on how long ago the credit agreement or any related agreement was made. The matters to which the court is obliged to have regard under subsection 2, because it thinks them relevant, are likewise not limited in time. And then paragraph 25, fifth, as well as requiring the court to make a very broad and holistic assessment to decide whether the relationship between the creditor and the debtor is unfair to the debtor, the legislation also gives the court, where a determination on fairness is made, the broadest possible remedial discretion in deciding what order, if any, to make under section 140B. Section 140B gives the court an extensive menu of options from which to select, but says nothing at all about how the selection may or should be made. On the face of the legislation, the court's discretion is entirely unfettered. It is, I think, clear that the court is not in these circumstances required to engage in the kind of strict analysis of causation, loss, and so forth that would be required, for example, in deciding what remedy to award in a claim founded on the law of contract tort. Some constraint is, however, imposed by the consideration of the general purpose of an order under Section 140B. In principle, the purpose must be to remove the causes of the unfairness which the court has identified, if they are still continuing, and to reverse any damaging financial consequences to the debtor of that unfairness, so that the relationship as a whole can no longer be regarded as unfair. That, my lords, is Smith. And then finally, in the run of Supreme Court cases, there is Johnson.
And you refer to Smith because you say that the passages you've looked at demonstrate that if you're talking about an unfair relationship, it's an individual assessment.
Yes, my lord.
Anything else?
I'm going to bring it all together in a moment, but that's the thrust of it. You've got to look at each individual relationship in a holistic manner, taking into account all factors, both for and against, both on the debtor side and the creditor side.
And Smith and Fleming go together on that.
We do.
Thank you.
And then Johnson and First Rand, which is authorities for tab 52. Now this case, as my lords know, concerned, among other things, an unfair relationship claim against a motor finance lender. And as I said earlier, there were 3 cases before the Supreme Court, but by the time the case reached the Supreme Court, there was only a live unfair relationship claim in one of them, namely Johnson and First Rand Bank. And there was a single judgment given by the justices starting at page 1415.
Forgive me, I've just gone on somewhere.
Yes, sir, my lord.
What tab number is it?
52.
50 how many?
2. 5-2. 2, my lord. 5-2.
Thank you.
Now, the facts of Mr. Johnson's case are set out in a section starting at page 1423, at paragraph 39, where we can see that the dealer who sold the car to Mr. Johnson was called the Trade Centre Wales Group. You can see that in the third line. And then in paragraph 40, the finance was provided by First Rand. You can see that in the third line of paragraph 40. And then over the page at paragraph 43, the Trade Centre Wales and First Rand had at the material time a rates and terms agreement in force between them, included in a letter dated the 18th of July 2017, under which the dealer had a discretion as to the interest rate between 8% and 13%. Commission was payable in 2 elements. First, commission of 80% of the difference between the minimum discretionary interest rate and the rate actually charged. Secondly, a revenue share of advance commission at 25.8% of the total amount of credit. Since the interest rate chosen for Mr. Johnson was the minimum 8%, the first commission element was nil, but the second element amounted to 1,650 odd, and this was the commission actually paid by First Rand for the Trade Centre Wales. And then paragraph 44, the rates and terms agreement between First Rand and the Trade Centre Wales included a commercial tie under which the Trade Centre Wales was required to offer all its business to First Rand, which had first refusal. That tie was not disclosed to Mr. Johnson. Now, the substantive consideration of the unfair relationship claim starts right at the back of the judgment on page 1485 at paragraph 291. We can pick it up, I think, on the following page, page 1486, at paragraph 297, where the justices say the test of the unfairness of the relationship of debtor and creditor is stated in general terms, which permit...
I'm so sorry, I haven't got there yet. Paragraph?
297.
Thank you. Thank you.
The test of the unfairness of the relationship of debtor and creditor is stated in general terms, which permit courts to take account of a very broad range of factors. The application of the test in each case will inevitably be a highly fact-sensitive exercise, and then they cite Plevin and Smith. And then starting over the page, paragraph 299, the court identifies Mr. Johnson's pleaded case in relation to the unfair relationship claim. And then starting at paragraph 305, they consider the judgments below. And then on page 1492, above paragraph 317, the court come to address the question as to whether the relationship was unfair. And I think we can pick it up at paragraph 319, where they say, in its helpful written case, the FCA, while observing that a relationship will not be unfair, merely because a commission was paid of which a borrower was unaware, has identified the following as relevant factors pointing towards unfairness. The court agrees that the factors in this non-exhaustive list will normally be relevant. The size of the commission relative to the charge of credit, the nature of the commission, because, for example, a discretionary commission may create incentives to charge a high interest rate, the characteristics of the consumer, the extent and manner of the disclosure, including by the broker insofar as Section 56 is engaged, and compliance with the regulatory rules. Then over the page, they identify, or rather refer to, the document that was given by the dealer to Mr. Johnson, which was entitled Suitability Document. And if we look alongside letter E, they say it is clear that the commission was not disclosed. Nevertheless, we agree with the FCA and Court of Appeal that the mere fact there has been no disclosure of the commission, or only partial disclosure, will not necessarily suffice of itself to make the relationship between lender and customer unfair for the purpose of the CCA. It is a factor to be taken into account in the overall balancing exercise required under Section 140A. And then on page 1494, we can see at paragraph 323, the court considered the size of the commission and the relative size of that commission to, for example, the total charge for credit is identified. And then at paragraph 324, we can see in the first sentence that Mr. Johnson's counsel, Mr. Weir, relied heavily on the decision in Plevin, and in particular, the tipping point analysis in paragraph 18 that I asked my lords to read a few moments ago. And then we can see this at paragraph 325. Mr. Weir submits, by reference to Plevin, that the question is whether the commission was so high that it was unfair to leave Mr. Johnson in ignorance of the amount because he would be unable to make an informed decision whether to enter into the credit agreement. He accepts the context is critical to assessment of whether the size of the commission renders the relationship unfair. He submits that in the present case, the size of the commission was clearly relevant to the claimant's decision-making, not least because most people would assume a commission of this size must have had an effect on the amount they were paying under the credit agreement. He submits that the interest and other charges which make up the APR represent the cost of finance and are the appropriate comparator. He submits that the fact that the commission was 55% of the total charge for credit equates to the position in Plevin, where the commission was 71.8% of the cost of PPI policy premium. It is his case that Mr. Johnson was in no better position to assess the true value for money of his credit agreement, but by reference to the APR, and Mrs. Plevin was her PPI agreement by reference to the premium, and the fact he needed finance to finance the car made him no more vulnerable. And then paragraph 326, the analogy between the facts of Plevin and those of the present case is imprecise, and it is not possible simply to apply the reasoning of the Supreme Court in Plevin to the present case. The cases are concerned with different products on different markets, In particular, as Mr. Howard points out on behalf of First Rand, the decision to enter into a finance agreement was not optional for Mr. Johnson, because without finance he could not pay for the car. Had he decided whether to purchase the car at all, he had to decide whether to purchase the car at all, and if so, with which finance product. He had been provided with information as to the price of the car and the cost of the finance agreement, interest rates, fees, APR, and monthly payments. He was at least in a position to compare the cost of the finance agreement offered to him with other options available on the market. Nonetheless, the fact that the undisclosed commission was so high is a powerful indication the relationship between Mr. Johnson and First Rand was unfair. And then the court went on to consider Mr. Johnson's evidence at trial, and we can see at the foot of that page, paragraph 329, that the court found that the failure to disclose to Mr. Johnson the existence of the commission was a breach of Conc 4.5.3R. And then over the page from paragraph 330, the court deal with the commercial tie between the Trade Centre Wales and First Rand and its non-disclosure to Mr. Johnson. And they say that's a further consideration highly material to the issue of unfairness. You see that at paragraph 330. And then over the page at paragraphs 333 and 334, the court agree with the conclusion drawn by the Court of Appeal that there was a false impression created and a suppression of the truth about the nature of the dealer's role by reason of the statements made in the suitability document. And at paragraph 335, at the foot of that page, they conclude that further provisions of Conc were breached. And then over the page at paragraph 336, they consider the effect of Mr. Johnson's failure to read the documents. And they say, in deciding whether to make a determination of an unfair relationship between creditor and debtor under section 140A, the court is required to have regard to all matters it thinks relevant. The assessment involves a balancing of relevant factors. In the present case, an important item to be placed on the other side of the scales is Mr. Johnson's failure to read any of the documents provided by the Trade Centre Wales, either before concluding the agreements or during the 14-day withdrawal period which follows. And then it goes on to consider, the court go on to consider the detail of that issue before, at the foot of that page, drawing its conclusions at paragraph 337, where they say, in light of the errors made by the Court of Appeal, we have given careful consideration to whether the issue of unfairness should be remitted for decision by a district judge, or whether it's open to this court to decide the matter. We take the latter course for the following reasons. One, there are no outstanding factual disputes in relation to this issue. This court is fully informed and has had the benefit of very detailed and expert submissions on the relevant law and its application of the facts. We consider we are as well placed as a district judge would be to decide it. Two, be contrary to the overriding objective to remit this issue. It would be a disproportionate use of court time, and the parties would incur further costs unnecessarily in this individual case of relatively low value. Three, we note the submission on behalf of the FCA that the public interest in achieving finality and clarity in the law under section 140A in the motor finance context, and the consistency in respect of the many thousands of pending complaints and claims would be aided by an authoritative ruling by this court. The FCA submits that the prospects of a remittal should not be permitted to delay the resolution of these issues. For all the reasons set out above, we've come to the very clear view that the relationship between Mr. Johnson and First Rand was an unfair relationship. And then 338, so far as remedies are concerned, section 140B confers very wide powers. We consider the commission should be paid to Mr. Johnson together with interest from the date of the agreement. And then they draw their overall conclusions in paragraphs 339 and 340. Now, my lords, we say that 5 points can be drawn from these Supreme Court cases, along with the wording of the relevant statutory provisions. At first, an assessment of fairness requires an extremely broad and holistic inquiry, and the court is mandated under section 140A2 to have regard to all matters it thinks relevant to the question of fairness. There are therefore myriad possible factors that could render any particular credit relationship unfair, or equally weigh in the balance so as to render the relationship fair. And there is no limit to what those factors might be on either side of the scales. As such, there is no universal test for the application of section 140A. It instead turns on the court's assessment of all the relevant facts in any particular case, and accordingly, it is a highly fact-sensitive exercise. Now, the respondents...
Is that number one?
That's number one, yes. And this is, I'm about to make a sub-point on number one. The respondents say in their skeleton argument at paragraph 80b that the word relevant in this context cannot mean unremarkable or commonplace facts. But we say there's no warrant for the application of that gloss. The statutory language could not be clearer. It extends to anything that the court considers relevant. And that might well be something that is commonplace or unremarkable on its own in the context of a particular claimant, or perhaps carries some different or greater significance when viewed alongside other relevant considerations in relation to that claimant. So that's point one. Point two is the assessment is as to fairness of the relationship, not the credit agreement. And that relationship by its nature would extend over a period of time for so long as there is any sum payable under the credit agreement. And importantly, the assessment is as to whether the relationship is unfair at the time that the determination is made, not whether it was unfair at some point in the past. But in making that assessment, the court should consider the whole history of the particular relationship in question, going back not just to the making of the credit agreement, but any relevant act or omission that preceded it.
That's Lord Leggett.
Yes, that's Lord Leggett at paragraph 23. And the process is not in any sense time limited, nor can it be generic in approach. It has to be individualised and tailored to the relevant relationship under consideration. That's point two. Point three is that the assessment requires a balancing exercise. It is not just a question of the court taking into account points relied on by the debtor, but it must also take into account all factors, including any countervailing factors that it considers relevant. Point four is that the question whether the relationship is unfair is not the same as to whether the creditor has complied with any relevant regulatory rules. A much wider range of circumstances and considerations will likely be relevant to the fairness of the relationship, going well beyond the matters that are relevant to the application of the regulatory rules. So, for example, in the motor finance context, just because there has been no disclosure of the commission, that does not necessarily suffice to render the relationship unfair. Instead, it's just one of a number of factors that go into the mix. And in the motor finance context, there is no tipping point above which the commission is so high that the relationship can automatically be regarded as unfair. My fifth and final point is that if unfairness is established at the first stage, at the second stage, when deciding what, if any, remedy to order, the court also has the broadest possible discretion. And just because unfairness is established, it doesn't follow that the remedy will be imposed. Again, a broad consideration of all relevant factors is required. Now, I want to pick up at this point, at this stage, a point that my learned friend, Mr. Kavanagh, made in his skeleton argument regarding remedy.
Are you leaving Johnson?
My Lord.
understanding those 5 submissions, what about paragraph 337 in the conclusions? Because your submission is, well, it all depends on the facts of each individual case. But the Supreme Court were keen to give a ruling because they said that they had in mind the consistency in respect to the many thousands of pending complaints and claims would be aided by an authoritative ruling by this court.
Yes.
And that, for that reason that they didn't remit. But your submission, taken to its logical conclusion, is that they were wasting their time doing that because everything will always turn on the facts of each individual case.
Well, my Lord, they were, as my Lord rightly observes, invited by the FCA to do that.
And that's one of the reasons that they did it.
Yes.
Because they say...
But we would respectfully say that the decision in Johnson has obviously not resolved or led to a settlement of the many thousands of claims that are out there, including those the subject of the present proceedings. And the reason for that, we say, is clear, namely that each case will turn on its own particular facts.
So you agree with the proposition I put to you that they were wasting their time? They were wrong?
Not wasting their time at all, because obviously they've set out the landscape as to how, in a motor finance context, an unfair relationship claim should be.
But they were wrong to think that people would be aided by an authoritative ruling because each case will turn on its own facts.
Well, my Lord, there might well be some fact patterns which are similar to Johnson, where you've got a high commission coupled with a undisclosed commercial tie without any material countervailing factor. And obviously in those instances, the decision in Johnson might assist in the resolution of those other cases.
Is that as high as you put it?
Well,
I mean, I'm wondering, it was your clients, close brothers, who took this case to the Supreme Court. Very much on the same lines as my Lord. The questions I've written down for you, there are 4 of them, are: 1, does it bind any other claims against close brothers?
No.
No. Does it dispose of any other claims against close brothers?
To be clear, my Lord, there was no unfair relationship claim before the Supreme Court as against close brothers.
Say that again?
There was no unfair relationship claim as against close brothers before the Supreme Court. It was only first round.
Does it, I think the question still remains, does it bind any other claims against close brothers? To which your answer would be no.
Well, it would be no, my Lord, because, as I say, there was no close brothers.
Right. Does it dispose of any other claims against close brothers?
No.
Why was it taken to the Supreme Court for £1,650?
Well, my Lord, as I say, there was no close brothers. There was no close brothers unfair relationship claim before the Supreme Court.
All right,
obviously, the principal issue before the Supreme Court was in relation to the equitable and common law claims. But obviously, in the Johnson case, there was an unfair relationship claim, which was still extant. And so the Supreme Court obviously needed to deal with that because that was one of the matters before it.
But you can, on the basis that it's not close brothers, you can duck my questions to some extent. But the question, which I don't think will go away, is why was this taken to the Supreme Court on a claim for £1,650? And question 4, are these claims, which as I understand it are typically for something between £500 and £1,500, that sort of order, are any of them viable on an individual basis?
Yes, my Lord. I mean, and we'd say, in response to those questions, that the proof is in the pudding. But first, Johnson has not resolved the many thousands of cases that are out there. And secondly, the fact that there are the many thousands of cases out there show that people are pursuing these cases on an individual basis through the county courts. And they're being resolved on the small claims track. They're not presenting any difficulties. My learned friend, Mr. Kavanagh's solicitors, have indeed brought a number of individual claims against my clients, and they are being pursued in the ordinary way. Secondly, there is simply no evidence before this court that should these claims, subject to these 8 claim forms, be disaggregated, that these claimants wouldn't pursue them on an individual basis, or indeed couldn't pursue them on an individual basis.
Well, I mean, ultimately that would depend on what case management decisions were made down the line for the trying of cases.
But there's no evidence that if the court were to uphold His Honour Judge Worster, that these people would abandon their cases. And indeed, there's no reason to think they would, because other individual claimants are pursuing them.
No, but you're unlikely to persuade us that the motivation for this battle royal on claim form 8 or 5,000 is to do with altruism or to do with wanting to contribute to the jurisprudence, which has been set out so neatly for us by the Supreme Court in 3 cases already. There is a bigger battle going on behind here, as in all multi-party claims. So it remains a question whether we can answer it or not. Why, how, well, we'll come to it later. I've asked my questions. Thank you.
Having made those 5 points, my lord, I was just going to pick up a point that Mr. Kavanagh had made in the skeleton about remedy, by reference to my 5th point. And he says at paragraph 102 of his skeleton that but-for causation is not required for a finding that a relationship is unfair or for a remedy to be granted. Now, I accept that but-for causation is not required for a finding that a relationship is unfair, but I do not agree that it's irrelevant, and certainly not at the remedy stage. Given the breadth of the discretion at the remedy stage, it will be relevant to consider the counterfactual had the unfairness not arisen. And that's a point that one can see in a judgment from Mr. Justice Zaccaroli, as he then was, in Authorities, Volume 3, at tab 42, which is a case called Farrell Holdings and Campbell.
Put Johnson away.
So volume 3, tab 42, at page 1047. Where Mr. Justice Zaccaroli says at paragraph 767, where the court finds the relationship is unfair, then the general purpose of an order under section 140B is, where the relationship has come to an end, to reverse any damaging financial consequences to the debtor of the unfairness that the court has identified. The order made should reflect and be proportionate to the nature and degree of unfairness which the court has found. It should not give the claimant a windfall, but should approximate, as closely as possible, the overall position which would have applied had the matters giving rise to the perceived unfairness not taken place. So one is looking to identify the position that would have applied had the matters giving rise to the unfairness not arisen. And in doing that, the court necessarily has to consider what would have happened in that counterfactual scenario. And we say, therefore, the court would need to grapple with the sorts of points that we have identified in paragraph 22 of our skeleton argument when considering the question of remedy. Now, before leaving the Supreme Court decisions, I will just make one further observation, and that is that it may not have escaped the court's attention that all these 3 cases, Plevin, Smith and Johnson, were claims that were started by the claimant on an individual basis, which were determined alone and then worked their way up through the court system. And one of the points made by His Honour Judge Worster in his judgment at paragraph 45 was that if points of principle emerged in the present claims, that they could be determined in individual cases and appealed up through the courts, which is exactly what has been happening without any difficulties, both in the PPI and motor finance contexts. Now that's all I was going to say at this stage on unfair relationship claims. What I want to now do, if I may, before I come to the Mr. Justice Ritchie's judgment, is say something about the claimant's claims here. And it's important, we respectfully say, not to lose sight of the vast breadth of claims with which we are here concerned.
Sorry, let me just put that away.
Which, as
Have regard to the vast what?
the vast breadth of claims with which we are here concerned, which, as the court knows, total over 5,000. And we've tried to give a flavour of this in our skeleton argument, which is at Core Bundle 1, tab 17, at page 279.
Sorry, I just managed to turn my machine off. I'm just retrieving my. So, could you just give the reference?
Sorry, Core Bundle 1, at tab 17, page 279.
Yeah.
Yeah, thank you.
Where we say at paragraph 2.3, underlying every one of the claimant's alleged claims is an individual transaction. Each such transaction entered into over a lengthy period. Black Horse, 23rd of March 2009 to 17th of December 2020. Close Brothers, 13th of July 2007 to 25th of January 2021. Involve one of potentially hundreds of motor dealers of varying sizes and descriptions, from whom the claimant sourced and negotiated the acquisition of a motor vehicle. Those dealers conducted face-to-face discussions with each claimant, each of which was by definition unique, and over which the lender was likely to have had very little of any visibility, providing the claimant with their own standard form documentation and applying their own processes at the relevant point of time. Where finance was required, the dealers introduced the claimant to a lender or a number of lenders, sometimes via a third-party broker, that would also have its own unique documentation. Some of the underlying transactions involved new vehicles, others were for used vehicles. Some customers paid cash deposits in varying amounts, some did not. Some traded in their existing vehicles, others did not. Some customers are likely to have received discounts or other incentives relating to the vehicle, such as deposit contributions. Some may have received these by way of an advertised manufacturer or dealer offer. Others may have directly negotiated discounts on the price of the vehicle and or ancillary products, or perhaps an improved trade-in allowance. Some customers may have been able to avail themselves of other sources of finance or to purchase the vehicle outright. Others may have had less choice. The personal circumstances of each customer will also differ. Now, the very same point can be seen quite starkly from an analysis produced by Vauxhall Finance, one of the other appellants in this case, which is set out in my learned friend Mr. Finch's skeleton argument, which is in the same volume at tab 21 at page 355. Where at paragraph 19 he sets out a passage from the evidence that was adduced at first instance, which explained as follows. Across the claimants bringing claims against Vauxhall, there are agreements from 2014 through to 2022, 118 different dealers, 52 different dealer groups, dealer contributions which may or may not have eclipsed the commission, ranging from £0 to £4,440. Commission payments ranging from less than £100 to more than £2,000. Cases where special promotions meant the rate applied was below the dealer's base rate. APRs ranging from 2.88% to 22.31%. A variety of different promotions which fixed the commission amount at various different sums. A number of agreements where the claimants defaulted. Accounts which were subject to COVID forbearance. A number of claimants voluntarily surrendered. And a number of agreements which were otherwise settled early. And it's to be expected that similar issues will apply or arise across the cohort of claims against each of the defendants. So in respect of these 5,000 odd claims, we are talking about a vast array of different circumstances, with each individual transaction inevitably differing from the next. Now, the claimants blithely say that the facts across the 5,000 odd cases will be materially the same, but there is no pleaded or evidential basis for that assertion. And at the time that the claim forms were served, no particulars of claim were produced, nor had the claimants sent any pre-action correspondence indicating that omnibus claims would be issued. And indeed,
had they sent pre-action correspondence generally?
I think in respect of some of the individual claims, I can check that over lunch.
Some of the individual claims,
Check that.
but nothing to indicate generally. And can I just go back to one thing you said before? Is it right? Did I hear you correctly? There is in fact no evidence, and particularly specifically no evidence from the claimants about the implications for access to justice.
Correct. And the judge, Mr. Justice Ritchie, acknowledges that in the judgment. But that nonetheless didn't seem to stop him going on to make some observations about that. But I'll come to that later on. There's no evidence of access to justice. There's no evidence, for example, about the claimant's funding arrangements.
No.
I mean, they were asked about that. They refused to give any information. There's no evidence to suggest that my learned friend solicitors wouldn't act for these individuals or act for these claimants on an individual
But the
basis.
short answer, or your short answer, is there is no evidence that the difference between individual claims forms and composite or omnibus claims forms have implications for access to justice.
Correct. And none of the claimants have suggested they wouldn't bring the claims on an
I
individual.
mean, there might be arguments about whether that's relevant under CPR 7.3 anyway, but we don't need to go there. Thank you.
And I was making the point that at the time the claim forms were served, there were no particular claim produced. And indeed, it now seems clear that the claimant's solicitors had in fact conducted very little by way of due diligence in relation to the claims, as a not insignificant number of the claimants did not in fact enter into discretionary commission arrangements at all, and many of their claims have since been abandoned. Now,
Where do we find that?
I will have to dig out a reference for that rule.
Right. I mean, there's been references to weeding out.
Yes, the weeding out relates to that issue. I think, I'll be corrected over lunch if I'm wrong about this, but I think the claims now stand at 5,200 odd. Originally, I think there were over 6,000 claims. I think there might be a reference in His Honour Judge Worcester's judgment to that. I'll see if I can find it.
So
the claimants accepted, at least at one point in time. I should make clear, my first appearance in this case is in the appeal court. I didn't do it below, so I'm, in one sense, catching up as well. But as I understand it, below, the claimants were always very clear that if it was identified that their arrangements were not discretionary commission arrangements, they would abandon those claims. And indeed, as I understand it, they did abandon those claims up until a point in time where they decided not to abandon those claims. So I think there might still be some non-discretionary commission arrangement cases which haven't been abandoned, albeit...
But how would anybody know? As I understand it, there's a claim form with a schedule of names and addresses.
Correct, but the pleaded allegation...
Well, we'll come to the generic particulars of claim, but as far as the claim forms are concerned, the facts, as I understand it, all we have are names and addresses.
And I think, I'll check this, but I think there's credit agreement numbers as well, and dates for agreements. There's not just the names and addresses.
Right, is that in the attached to the claim forms?
I think there was a separate schedule to the particular claim. We're not going to come. We're not going to come to the generic.
Well, if you're going to come, that's fine. But anyway, you were saying.
Well, can I just deal with the point that the claim form was served, no particulars. that point in time, the claimants applied immediately to transfer the cases to the High Court.
Yeah.
And that matter, in fact, came on within a matter of days. I think 3 days, in fact, after the claim form was served. It came before us on a Judge Worster. And it's worth us having a look at the order he made on that occasion, which is in the supplemental bundle at tab 24. At page 265. And this order was not appealed.
I thought one person tried to appeal it.
That I think
Is that something different?
that was there was one appeal in respect of the order that the cases wouldn't be transferred to the High Court. I think it was an appeal against Vauxhall Finance. That appeal then wasn't pursued.
Thank you.
This order, I'm showing my lord now, did not determine the transfer application, but included other directions set down by His Honour Judge Worster upon the cases first coming before him. And if we go please to page 267, we can see paragraph 2. Practice direction 49C is disapplied in respect of these proceedings until further order. Now, just pausing there, that we say is important. Practice direction 49C is the practice direction that applies to unfair relationship claims under the Consumer Credit Act. We don't need to turn it up, but if my lords want to look at it, it's in the White Book, Volume 1, page 1644. And under that practice direction, the particular claim should have been served at the same time as the claim form. That's paragraph 5.3. And as importantly, under paragraph 5.4, the practice direction expressly provides that a defendant is under no obligation either to serve an acknowledgement of service or indeed a defence. And then going back to paragraph 2 of the order, page 267, it says, the said this application shall not require the defendants to file acknowledgements of service and or defences to the particular claim referred to in paragraph 3A below until further order. So in other words, although the practice direction was disapplied, His Honour Judge Worster was putting back in effectively what the practice direction provided, namely there was no need for the defendants to either acknowledge or serve defences. And then paragraph 3A, that the claimants would serve generic predicts of claim in respect of each of the claims. So the upshot was that the claimants were required to serve generic particulars, but the defendants were not required to serve generic defences or indeed otherwise respond to the generic particulars, which, as I say, was in line with the Consumer Credit Practice Direction. And we say that that is of some significance given the criticisms that were made by Mr. Justice Ritchie in his judgment as regards the defendants failing to serve generic defences, to which I'll return in a little later. Now, ultimately, the application to transfer the claims to the High Court was dismissed by His Honour Judge Worster. We don't need to turn it up, but that order is at supplemental volume, tab 27, page 278. And that order was not appealed, subject to the wrinkle my Lord Justice Stuart-Smith identified of there originally being an appeal against Vauxhall Finance, but that appeal then not being pursued. So the upshot of all that is that whatever happens on this appeal, the claims will proceed and be determined in the county court, not in the High Court. Now, I want to look, if I may, fairly briefly at a generic particular claim. I'm going to look, if I may, at the Angel particulars, which are at Core Bundle 3, tab 74, page 908.
So the schedule that's referred to in the first paragraph is the schedule of names and addresses to which
I think it goes beyond that, my lord. I need to check that, but I believe it goes beyond that.
Well, can we just before?
Well, I don't think it's in the bundle, my lord.
What page are you on?
Is it not at 890 in the electronic?
Well, I think that's the schedule, my lord, to the claim form rather than the POC. I think there was a separate schedule to the POC. I will need to check this, I'm afraid, because I wasn't involved below. But I think the schedule to the POC goes further than the schedule to the claim form, but I will check that. And if I'm wrong about that, I'll be correct.
Okay, I'm confused. Generic particulars of claim are where?
Sorry, my lord. Core bundle 3, volume 3, tab 74,
74.
page 908.
908.
908.
Thank you.
Now, these, as I say, are the angel particulars. In other words, the particulars against Black Horse. And subject to one point, which I'll return in a moment, these angel particulars are broadly representative of the particulars advanced against each of the defendants. Now, there's obviously a lot of detail here, which I haven't got time to go through, but I want to highlight just if I may a few points. So page 909, paragraph 4, on the date specified in the schedule. Now, that's another reason, my lord, why I say the schedule.
So we don't have that.
I haven't seen it. I will, over lunch, inquire.
Is that right? Can I just ask generally?
It's certainly not in the bundles, my lord. I can give that assurance, because I'm very familiar with.
So I didn't appear below either, so I'm rather. I appear.
Well, you're appearing now.
We'll find out.
As I understand it, this might be the high watermark of the information provided by the claimants.
It is.
So I, for one, would be quite keen to see it. So perhaps that could be provided over the short adjournment.
So on the date specified in the schedule, which the earliest was the 23rd of March 2009, each of the claimants and the defendant entered into a regulated credit agreement within the meaning of Section 8.3 and the Regulated Activities Order. Now, just pausing there. So in the claim against in the claim against Black Horse, the Angel claim, we are talking only about regulated agreements. And the first credit agreement relied on, as we can see in paragraph 4, is dated the 23rd of March 2009.
Yeah.
The end period is not identified in that paragraph, but in relation to the claim, in relation to this claim, the Black Horse claim, the latest credit agreement relied on is dated the 17th of December 2020. So that's claims against Black Horse spanning a period of over 11 years.
So what was the end date?
17th of December 2020. And in fact...
And that end date comes from?
This schedule, which I haven't yet been able to identify.
Well, at least I'm on the ball that the schedule may be relevant.
And the claims against Close Brothers, the claims against Close Brothers span an even greater period. They span a period of 13 and a half years. And that's the 13th of July 2007 to the 25th of January 2021. So that's paragraph 4. But going back to the generic particulars, paragraph 5. Before the dates of the credit agreements, the claimants communicated with motor dealerships regarding their potential acquisition of the motor vehicles identified in the schedule that were the subject of the credit agreements. Paragraph 6. The claimants communicated the dealers and or to other intermediaries that they consulted in connection with such acquisition, that they required or desired the provision of credit to assist such acquisition. So this is all put in the most generic terms. There is no detail provided at all in relation to these communications, which are themselves the foundation of the claim, which then follows later in the particulars. And then if my lords can glance over paragraphs 7 to 10, you'll see what's said about the brokerage agreement.
Where does this information come? Had you given disclosure before this happened?
I think there had been, I think there had been pre-action correspondence or requests for information as against at least some of the defendants. And then if we pick up, please, at page 910, paragraph 11, we can see that there's reference to the period prior to the 1st of April 2014. And just pausing there, prior to the 1st of April 2014, the OFT was responsible for the licensing of consumer credit activities, at which point the responsibility then transferred to the FCA. And in paragraphs 11 to 20, you'll see various OFT guidance is pleaded, all relating, of course, to the period prior to the 1st of April 2014. If we then go, please, to page 916, you can see, starting at paragraph 21, the position from the 1st of April 2014 is identified. So that's the period at which point the FCA took over the regulatory supervision. And over the page, paragraph 22, you can see that various provisions of the Consumer Credit Sourcebook, or CONC, are pleaded. And at paragraph 25, over the page, you can see that there's one particular CONC provision which came into being later from the 2nd of November 2015. If we then please turn to page 921 at paragraph 33, we can see the first of the failures pleaded. And this is a failure on the part of the brokers, so not my client, a failure on the part of the brokers, that they failed to apply the general business principles in OFT 192. So this is all, as I say, during the OFT period prior to the 1st of April 2014. Then over the page, paragraph 34, we then get the first pleading of failure against the defendant, my client, failed to apply the general business purposes in OFT 192 to their motor vehicle business. And then we can see at A, failed to take all reasonable steps to ensure the brokers comply with the principles, and failed to take steps in B, failed to ensure in C. And then over the page, paragraph 35, we get another failing on the part of the brokers during the OFT period, albeit only during a subset of that period, so between June 2011 and April 2014. And then over the page again, paragraph 36, we get some plead of failures against my client, again during the OFT period, but for a slightly different period, in this instance March 2010 to April 2014. Then at paragraph 37 over the page, we get the plea relating to the period after the 1st of April 2014. So in other words, the time during which the FCA were the appropriate regulator. 37, the brokers breached the CONC rules, and then various things set out there. And we can see over the page, paragraph B is said to apply only in the period after the 2nd November 2015, so that's the rule I identified. It's coming into effect a little later, earlier. And then paragraph 38 on page 927. Again, during the FCA period, the defendant breached the CONC rules and failed to follow the CONC guidance. And we see A, failed to ensure brokers' compliance, B, failed to take reasonable steps to ensure brokers' compliance, and so on. And then finally at paragraph 39, we hit the relevant cause of action pursued in the claim, where they say the relationship between each of the claimants and the defendant under the relevant credit agreement was unfair to the claimants within the meaning of section 140A. And then over the page we get particulars of that plea. And A is the matters set out above. So that's everything we've just been looking at. And then at B and following, we get various other matters relied on, each of which is tied to the claimant's knowledge. So we see at B, they say the claimants did not know. C, the claimants did not know. E, the claimants did not know. F, the claimants did not appreciate. So that's the generic particulars in the claim against Black Horse. And I said that subject to one point, these particulars are representative of the claims against each of the defendants. And the point of distinction is that as against some of the defendants, the claims are not limited to regulated agreements, the point I showed you in paragraph 4, but extend to unregulated agreements. And in particular, that's the pleader position as against Aldermore Bank, Startline Motor Finance, and Vauxhall Finance. So what can we take from all this? We say 4 points. First, the claims fall into 3 broad buckets. First, claims relating to unregulated agreements. Second, claims relating to regulated agreements entered into prior to the 1st of April 2014, when the AFT was the relevant regulator. And third, claims relating to regulated credit agreements entered into after the 1st of April 2014, when the FCA was the relevant regulator. That's point 1. Point 2 is that within each of the AFT period and the FCA period, there are different sub-periods depending on when the relevant guidance or rule was introduced. And in fact, on analysis, there are 4 sub-periods during the AFT period and 2 sub-periods during the FCA period. Third, there are no facts pleaded in the generic particulars beyond the generic. The pleading does not descend to any detail about the dealings each of the claimants had, and it simply does not provide a basis for my learned friend to say that the facts of all these cases are the same or materially the same. And fourth,
it's a desktop pleading.
it is. And indeed, if one were to study them, one will see that not only is it a desktop pleading, but actually they just simply change the heading across the defendant cohort. And fourth, even absent the individual fact being pleaded, it's obvious on the face of the pleading that material differences will arise in relation to different claimants, not only in the sense of whether their credit agreement was entered into in the OFT period or the FCA period, or indeed whether it was regulated at all, but also to, for example, that individual's precise circumstances, their particular communications with the dealer in question, and indeed their knowledge and understanding, which, as we saw, is one of the factors relied on in the particulars of unfairness. Now, having looked at the generic particulars, I want to turn now to consider Mr. Justice Ritchie's judgment. And we say that he was plainly wrong to have concluded that these 5,000 odd claims could be included on omnibus claim forms. And fundamentally, Mr. Justice Ritchie failed to have proper regard for the exercise that's required by the court when assessing the unfairness of a relationship under the statutory provisions.
Sorry, he failed to have proper regard to
the exercise that's required by the court when assessing the unfairness of a relationship under the statutory provisions, and the highly individualised approach that is mandated, both at the stage of assessing fairness, but also when determining what, if any, remedy is appropriate. And he started from the flawed premise that there were common issues across all these 5,000 odd cases that could usefully be resolved. Now, Mr. Justice Ritchie appears to have started from the premise that the claims fell into 2 categories. First, claims that involved what he called, quotes, a very clear case of unfairness. And second, all other claims. In other words, those that were not a, quote, very clear case. And we can see this distinction being drawn in a number of places in the judgment, which is at core bundle tab 2, sorry, core bundle 2, tab 26. Page 433. It's like the judgment starts at page 420, but I want to go to page 433, please. Well, you can see at the bottom of that page, heading wider context. In that paragraph 28, he refers to the motor finance cases heard by the Court of Appeal. And if we can pick it up, please, on page 435, alongside the first hole punch. He says, I will set out a few more passages below, because I consider they are important when I come to consider the omnibus claim form decision. Lady Justice Andrews determined that the lender was liable to Johnson, despite the fact there was no full consideration of all the circumstances required under section 148A, and explained why thus. And he then sets out various paragraphs from Lady Justice Andrews' decision in the Court of Appeal. If we can turn the page, please, paragraph 170, just alongside the top hole punch. Lady Justice Andrews said, a relationship will not necessarily be unfair for the purposes of the 1974 Act, simply because a broker receives a commission from the lender and the borrower is not actually aware of that fact. The court is required to consider all the facts and to weigh their importance. If the commission is very high in relation to the sum required, that may in itself be enough to make the relationship unfair, where nothing or nothing of substance has been done to disclose the relationship between the lender and the broker. It's not necessary to develop this analysis further for the purpose of the appeal in Johnson, because the commission was very high in that case, and the true nature of the relationship between the lender and the broker was not disclosed by the lender, and actively concealed by the broker, acting as agent for the lender by virtue of section 56. It is a very clear case. And then Mr. Justice Ritchie says at paragraph 29, I shall call this the very clear case point. The Court of Appeal considered that the appellate judge could have and should have decided the relationship was unfair under section 140A on the facts found by the Deputy District Judge. Fairness is a matter of degree. A huge and obviously unfair commission is in relation to the sum borrowed, which is kept secret and undisclosed to the customer. The consumer may in itself be sufficient to satisfy the unfair relationship test. And he then returns to the same theme at page 438, where he refers to the Self and Santander cards case, which my Lord Justice Stuart-Smith will be very familiar with, and sets out a passage from my Lord's judgment in that case, which we say is important and on which we rely, where my Lord says at paragraph 56 of that case, it follows that application of sections 140A and 140B is bound to be fact sensitive. Even in a world of widespread mis-selling and unfairness, this is not a jurisdiction where on its proper analysis and application, a single predetermined criterion will always determine the question of unfairness, nor will one size of remedy fit all cases where the relationship is found to be unfair. It's easy to conceive of cases where allowing a full refund of all premiums, including commissions and profit share, together with interest, would be to do more than was required to remedy the causes of the identified unfairness. It's equally easy to conceive of cases where anything short of a full refund will fail to remedy them. That is why the Supreme Court in Plevin, while being clear that the commissions paid in that case were a long way beyond the tipping point, were equally clear the case had to be remitted to the county court to decide what, if any, relief under section 140B should be ordered, unless that could be agreed. And then Mr. Justice Ritchie says over the page, so the broad nature of the section 140A and B decisions was reaffirmed, and the tipping point, or what I've called the very clear case issue in relation to section 140A, was also confirmed. And then on page 457,
a bit of muttering going on up here. I was saying that although, needless to say, I think paragraph 56 is immaculate, I'm not entirely sure that it supports the observation that follows it from the judge.
No, I mean I don't dissent from that law, but what it does. I'm not relying on, as it were, his observation being reliant upon.
No.
I do rely on my Lord's reasoning in self, but the point I'm making at the moment, at least, is that the judge in his own mind had this notion there could be very clear cases.
Yeah.
Yeah.
I've resisted the temptation to go back and read self, but as I remember, paragraph 56 is after I've just done an analysis along the same lines as your analysis of the previous.
That's right, my Lord. In fact, I did consider this morning using self as the vehicle to take you through Plevin and Smith.
I'm glad you resisted.
I was going to say you took the very wise decision not to.
Because in fact, pretty much all the passages I've identified from Plevin and Smith, my Lord had identified in self.
Yeah.
And you did it almost, well, you did exactly the job that I did earlier, save obviously Johnson, which came later.
Well, so far, subject to anything that anyone else may say, I haven't changed my mind on self.
I was going to show you, if I may, page 457, paragraph 79, where again he brings out this very clear case point, where he says, as for the respondent's submission, accepted by the judge at paragraphs 37 and 39, the unfair relationship decisions can only be determined at trial by taking all relevant facts into account. That was never in dispute. The Supreme Court rulings are clear. Subject to the very clear case / tipping point examples, all cases are only going to be finally determined or more likely settled by such an analysis. So the judge took the view that there might be some very clear cases or tipping point cases where the size of the commission alone would render the relationship unfair, regardless of anything else. And we say with respect that analysis is mistaken, as we saw earlier in the Supreme Court's judgment in Johnson. The tipping point analysis referred to by Lord Sumption in Plevin, it does not read across to the motor finance cases, as the Supreme Court said in Johnson at paragraph 326. It's simply not possible to apply the reasoning in Plevin to motor finance cases in circumstances where they concern different products in different markets. As such, there's no such thing in this context as a very clear case or a tipping point above which the level of commission alone will render the relationship unfair. Instead, when assessing fairness, all relevant factors have to go into the mix, with a balancing of the points that arise in the particular circumstances of any given case. So there was no sense in which lead or sample cases could be used to establish what constituted a, quote, very clear case by reference to the level of commission alone, with all other cases involving a commission at or above that level falling like dominoes upon the lead or sample cases being resolved.
Well, if defendants are competently advised, if there is a very clear case, they'll settle it.
Yeah.
Simple. Get rid of it.
Now, in relation to claims that were not a very clear case, the judge rightly took the view that it was important to identify whether there were any common issues of law or fact across the cohort of cases that meant that they could conveniently be disposed of in the same proceedings. Now, it's necessary at this point to say something about the way in which the claimant's case on this topic has developed. Before His Honour Judge Worster, the claimant's position was that the single common issue was limited to the question of whether the regulatory regime required disclosure of the nature of the discretionary commission arrangement. And if we turn, please, to His Honour Judge Worcester's judgment, we can see what he said about that. That's in Core Bundle Volume 3 at tab 68. And we can go, please, to page 861. Under the heading Discussion, paragraph 33, He says the first issue to consider is whether there is sufficient commonality of significant issues between the claims brought by the same claim form that it would be useful or helpful to determine those issues within the one set of proceedings. The second is whether that determination will be binding on the other parties to the claim, i.e. the parties to the claim form. At the hearing before me on the 5th of May 2023, Mr. Clark, he was for the claimants at that point, submission was that all these claims were founded on a simple single premise, that the failure to disclose the discretionary commission arrangements as between the defendant and the dealer was a breach of conk. See paragraph 22 above. Now it's worth just going back to 22, which is on page 857, where the judge recorded this, paragraph 22. Mr. Clark accepted that in the final analysis, each claim turns on its facts. His submission was that each and every one of these claims is based upon what he describes as the single simple premise, that the relationship between the claimant as debtor and the defendant as creditor, arising from the credit agreement between them, was unfair because of the non-disclosure of the nature of the commission arrangements, which gave the broker or intermediary the discretion to fix the interest rate payable by the claimant under the credit agreement, and by doing so to increase the commission they received. And if we then go back, please, to page 861, where we were, in paragraph 34, we can see at paragraph 34, it's on Judge Worster, refers to paragraph 13 of Mr. Clark's skeleton argument, where he says that he submitted that the common issue would be limited to the question of whether the relevant regulation regime required disclosure of the nature of the discretionary commission arrangements. Given the limited nature of that issue, the defendants expressed some doubt as to whether its determination achieved anything. I might now add anything useful or helpful. They also questioned whether the decision in the sample case was binding on them or simply persuasive. Mr. Hardwick KC noted the remarkably limited parameters of this issue and directed me to the terms of Conk 4.5.3. He then sets out the terms of that provision and then says that after that, this he submitted was an issue which any county court judge was well able to consider and apply. I agree with that submission. Paragraph 36. Whether the conduct of the broker in any particular instance amounts to a breach of conk is one, not a complex matter, and two, will turn on the particular facts of the individual case. And then he refers to section 140A2. At paragraph 12 of his skeleton argument, Mr. Clark acknowledged that a determination in one case that the failure to disclose the nature of the discretionary commission arrangement gave rise to an unfair relationship between the relevant claimant and the defendant would not give rise to a binding precedent, that the relationship between other claimants and the same defendant was unfair. However, at paragraph 11 of his written submissions, he says this: the common issues here may be described as limited to two questions, being the question of breach of conk and the question of the principle of unfairness arising from non-disclosure of the discretionary commission arrangement. As I understand it, what is proposed is that the court be asked to determine whether a breach of conk arising from the non-disclosure of the discretionary commission arrangement may, in principle, give rise to a finding of unfairness under section 140A of the Act.
So just pausing there, although you said there was a single issue, it appeared by a process of development that they were identifying two issues. As I understand it, they were saying, well, there's the point as to whether non-disclosure was a breach of conk, and then whether that gave rise in principle to unfairness, which I think is a separate question.
And the judge then goes on to say in paragraph 38, firstly, this is by no means a difficult, perhaps even a controversial question. And then paragraph 39, secondly, I question the utility of a determination such as this. The question of unfairness will turn on a wide range of factors. Mr. Finch identified at least 18 in the skeleton argument. A breach of conk or compliance with it will be one, but the determination of the second common issue Mr. Clark now proposes is unlikely to provide a shortcut, or to use the language of Abbott, be useful or helpful. So, His Honour Judge Worster, a judge who was highly experienced in trying these sorts of claims, was of the view that there was not sufficient commonality between the claims to warrant their inclusion on a single claim form.
Susan, while you're there, do you want to take a call to paragraph 40? Finish that point.
Paragraph 40.
Yes, I've read paragraph 40 and the rest of all that. On the face of it, it didn't seem to me to make any difference to Judge Worcester's conclusions on the two issues that had been identified as being the key ones. But I'm sure if there are any points on those paragraphs, you'll make them.
Just to be clear on the second point, my Lord identified, the in-principle point. My learned friend is now accepting that you cannot have an in-principle determination of unfairness.
Well, with great respect, of course you can't. With great respect to Mr. Clark, of course you can't.
Now,
you could formulate an issue. You say, if with certain given facts, would that amount to, or would that give rise to an unfair relationship? It'd be pretty tricky, and you'd find some court at some stage saying we haven't got the right facts, and we haven't got this, and haven't got that.
well, with respect, my Lord, I would even dispute the premise of my Lord's observation now. I don't think you could make an assessment of unfairness by reference to defined facts. You have to look at the facts and factors in the individual case.
Well, on one view, you could have jumped on the bandwagon of paragraph 36. No, not paragraph 36, but Mr. Clark's single issue, and said, right, well, we'll decide that next week.
Well, I mean, it would tell you nothing.
It wouldn't have done any
It would
good.
tell you nothing at all, because as we now know from the Supreme Court, whether there's been a breach of conk or not doesn't equate to unfairness. Now, we saw in paragraph 39, I think it was, a reference to the 18 factors that Mr. Finch had identified. Mr. Finch is sitting over here today, and these are now...
These are now known as the Finch
The Finch factors.
and whatever else we will do in our judgment, we will ensure that fame
Perhaps Mr. Finch should stand up and take a bow.
that fame is maintained.
No, I don't want to steal Mr. Finch's thunder, but and I know he plans to say something about the Finch factors, but let me just show my lords what those are. They're in Core Bundle 1, tab 21. This is Mr. Finch's skeleton arm.
And I think they're the page before the reference you took us
Yeah, that's
to.
right. And they're set out there. I don't plan to go through them. They're on page 354. But if my lords just glance through them, you'll
So
get a
page
sense.
354. Yes. So
And-
you took us to 355 because
That's right.
we were looking at the
Back paragraph
the
19.
breadth of the claims, and I sneaked a page back to see that these were where they were set out.
So they're set up. These are the Finch factors. You'll see in paragraph 18 at the beginning. It's a non-exhaustive list. It's just an identification of the sorts of variables that these cases might give rise to.
Yeah.
And one gets a flavour from that list
Yeah.
as to the sorts of points that Finch had in mind. And we would respectfully say that Mr. Justice Ritchie totally misunderstood what the Finch factors represented. And rather than recognising them as points of distinction, he treated them as the defendant's list of common issues, without either side, in fact, suggesting in front of Mr. Justice Ritchie that course was appropriate.
Whereas you say it's the defendant's list, or Mr. Finch's list of individual issues.
Yes. Now, I want to make two points for present purposes. And the first is really the point I've just explored with my Lord Justice Stuart-Smith. The starting proposition that a claim turns on, quotes, a simple single premise, it is wholly untenable. But we know from Johnson in the Supreme Court that the non-disclosure of the commission alone cannot equate to a finding of unfairness. So the simple premise, even if established, would not suffice to automatically render the relationship unfair. And the fact that the essential basis of unfairness alleged in each case is the same misses the fundamental point that that essential basis alone could not result in a finding of unfairness, as well as the broader point that an assessment of fairness does not turn only on a single factor relied on by a claimant, but a balancing of all factors. Second, even putting that point to one side, that the claimants rightly recognised before His Honour Judge Worster that the individual cases would differ, and they accepted that at least some of the so-called Finch factors could be relevant to a determination of unfairness, or at least to the appropriate remedy should unfairness be established. And if we can go, please, to the supplementary bundle. At tab 2, page 39, we have here the claimant's skeleton argument at first instance, setting out their position as to why they should be permitted to use omnibus claim forms.
Yeah.
And if we go, please, to page 50, paragraph 19, that they say, page 50, the claims brought by the claim forms here should not be characterised in the same way as a huge variety of unitary claims. As will be apparent from the generic particular claim, all of the claims are based on the single simple premise that the relationship between the claimants as debtor and the defendant as creditor, arising from the credit agreement between them, was unfair to the debtor, owing to the non-disclosure of the nature of the commission arrangements between the creditor and an intermediary, by which the intermediary was given discretion to fix the interest rate under the credit agreement on behalf of the creditor, and thereby to increase the commission payable by the creditor to the intermediary. The proposition does not depend upon the individual circumstance in which the credit agreement was made, provided that, and then they set out various points there. And then we get this at paragraph 20. That is not to say that there may not be differences in the circumstances in the individual cases. In paragraph 21 of Mr. Finch's skeleton argument, there is a list of individual circumstances that it is contended that the court would have to consider in each case. Some of those relate to whether the elements of the claim are made out, i.e. whether there was a commission, whether the commission structure involved a discretionary commission arrangement, and the extent of disclosure made. Although the list refers only to disclosure of the fact of commission, the amount of commission, and not of the discretionary nature of the commission arrangement. Others are of little or no relevance to the determination of unfairness under section 140A, but they may be relevant to the appropriate order to be made under section 140B, i.e. the size of the commission, the lower interest rate was available to the claimant and defendant, and the history of the account. While it must be correct that each claimant's claim will turn on its own particular facts, to the extent that such claimant must prove the necessary elements to establish unfairness in the particular relationship, and that the order appropriate to redress the unfairness will reflect the particularities of the relationship, it remains the case that the essential basis of the unfairness alleged in each case is the same.
And you take the first half of that sentence as a clear concession.
Yes.
Yeah.
Now,
Mr. Goodall, the difficulty I have with all of this is that it's all speculation.
and that's exactly one of my points, my lord.
There isn't a single pleaded out claim to which any of this could hang.
No. And this is exactly my point. And we say...
We have 4 full Libre Arch files here, but really they're all speculation about what the claims might be.
Yeah. And this is one of my fundamental points, is the judge, Mr. Justice Ritchie, got involved in some entirely hypothetical exercise as to what these cases might look like. And he did that against the backdrop of being very critical of my clients. But my clients not telling him what the issues were. But that lost sight of so many different aspects of fundamental principles of litigation. Namely, it's for the claimants to say what their cases were. The burden is on the claimants to justify the use of 7.3. Either they can do that or they can't. It's not for my clients to tell them what the issues are. They themselves need to identify what the commonality is. And they simply just fail to do that. And as I say, my learned friend blithely says all these cases are the same. There's no basis for that contention. And indeed,
The mere fact, I suppose it's this point really, that the mere fact that there are lots of claimants, does that mean that you shouldn't plead the case that the civil procedure rules require you to plead? I mean, if this was if Mr. Angel had pursued his claim individually, he couldn't have simply provided his name, address, and the date of the agreement.
No, he'd be saying, you know, on the 5th of March 2019, I went into the Volkswagen dealership in Reigate and I purchased a Volkswagen Polo for X and I negotiated the following terms and no one told me Y or Z. And the Consumer Credit Practice Direction, as I said earlier, makes clear that when you serve your claim form, you serve your particulars. Yeah. And Part 16 of the CPR makes it clear that your particulars should set out the facts relevant to your case. There's none of that here.
Well, the CPR makes that clear.
Yes, yeah, Part 16.
Because what we're talking about under 7.3 is ordinary civil litigation. That's 7.3.
Yeah, but we're not. This is not, and it's quite important to recognise it. This is not a case where it suggested there could be a GLO. It's not a case where it suggested there can be a representative claimant.
Well, it hasn't been. I mean, those points haven't arisen. Whether there could have been a group litigation order is one of the first things that I was thinking about, and I think my Lord Justice Stuart-Smith as well, since we both have extensive experience of case managing GLOs through to trial. But that hasn't arisen here. So other than noting that it's something that the CPR provides, it may not be relevant. No. But the provision of something concrete may be a different point.
When were the claim forms issued? Which year? 2022. So there's a limitation problem.
Possibly.
But the dates you've given us stretch well back before. I mean, viewed from here, this has many of the hallmarks of a fairly typical process whereby claimants issue possibly too early when they don't have enough information in order to avoid limitation problems. And then the defendants, and I don't say this tendentiously, go into the trenches and start scrapping.
I mean, just to be clear on that,
I wouldn't. I'm sure that's not an elegant enough description of what you're doing, but this is a familiar routine.
Well, my Lord,
I've been on both sides of it.
Well, my Lord, I'd make 2 points about that. First of all, I think it was made clear, and I think Judge Worcester's order makes clear that as and when the claims are disaggregated, the claimants get the benefit of the date of the original claim form. So there's no benefit, if my Lord has in mind, from our point of view.
No, I wasn't thinking about that.
I mean, I'm slightly cautious about my Lord's suggestion that this sort of tactical skirmishing, because it actually, I know my Lord might have started with some reservation about what I say is going to happen in this litigation, but this goes to the sort of fundamentals of what we're facing here, which is a sort of stack it high, set it cheap, pro forma POC with no detail at all. And as I say, a law firm which is sort of warehousing claims to load onto these claim forms without having done any kind of due diligence as to what these people actually might have actually been involved in on the ground. And the suggestion somehow, which we'll see that the judge made, that we, the defendants, are at fault, is, we say, nothing short of remarkable.
Well, I wonder.
I'm not going to say anything else.
I wonder if that's a convenient moment, Mr. Goodall. Thank you very much. I think it would be useful, please, having given a direction that we have a live transcript. I'd be very grateful if by 2 o'clock we had a live transcript. I've had numerous live transcripts before and never have had to give a password. So I don't think in the 8 years I've been in this court I've had an Opus 2 password. I think I did back in the day, but that's long
ago.
I was going to say that's long gone. So if somebody could see to it that I don't have to fill out a password, but I can have the live transcript that I ordered, that would be kind.
Hopefully the transcriber will pass that on to her colleague and it will be sorted.
Okay. So I'll leave it there.
Thank you, my Lord.
All right, 2 o'clock. Thank you very much.
All right.